Welcome to Punished for Protecting News Live with Francesca Amato.
Hello, everyone. Welcome to Punished for Protecting News today. Wow. Today we have some story for you. I'm here in Westchester County in New York. And yes, sitting next to me is Elizabeth Munshine, and she is an attorney.
I am an attorney, but I am a pro se litigant in the family courts. I am not represented by counsel. I'm representing myself, but as a pro se person.
And you are licensed in what state?
I'm licensed in New York, New Jersey, and Illinois.
New York, New Jersey, and Illinois. So what happens when an attorney decides to expose the family court? Well, Francesca drives down to Westchester and does an interview, right? You were shocked, weren't you, when you entered this diabolical system?
I got caught in the system years ago, and I couldn't get out of the system, and I lost custody of my children. And I was put into supervised visitation. And New York State is one of the few states that doesn't give you a path to get out. Once you're put in supervised visitation, you're thrown there. You're not told how to get out, how long it's going to last, or even the reasons why you're there.
Well, let's talk about that. And I do know the laws regarding supervised visitation. And I do know that since I do this nationally, that they have to have a genuine finding of unfitness, drug dealing, drug abuse, addiction, child abuse. Your background is immaculate.
It's clean.
So they had no finding of anything.
The only thing is the therapist that the children were seeing did like me.
Yeah, and that's very typical. And I can relate to that.
You know, there was no hospitalizations. There was no mental health treatments. There was no anything. The children were thriving. They were doing the best they could. They were in one of the top school districts in the country. And yet I still got this finding, but I didn't know back then what a mess family court was.
Until you became on this side of the fence, so to speak. But you were not an attorney for family court, a family law
attorney. I am not a family law attorney. I have no interest in practicing family law. This is born out of necessity.
Correct.
Because as an attorney representing somebody in family court, that attorney can only go so far because they have to come back the next day to represent somebody else.
Yeah, and no, we do talk about this often, and we do respect attorneys because they are trapped in the bar association.
Well, they have a problem because you know what? They have 100 clients and they need to represent their 100 clients to the best of their ability. If they take on the judge for that one client, those 99 other clients are going to suffer. They're going to suffer, and then their career is over. They're going to be blackballed. So I will be blackballed at the end of this, Westchester County.
Now, there's two different types of, to me, there's the attorneys, because I have attorneys on my board, and I have attorneys that are great people, but they are trapped, and it's not something that I personally could do. I'd have to get a job someplace else, knowing that I can't help with my full moral compass. But at the same respect, we have the other type of attorneys that are ruthless, that are the opposing counsel, that are there to play that game, don't lie on the stand. You know, that's the ones that are running this monkey business. And you've run into this, obviously, but not just with the attorneys, like the child, the gals,
the law guardian.
Let's talk about that.
The law guardian herself is decided that I'm a liar. She recently wrote a letter to the court, and I had to refute and show proof of what I had done. And I'm very lucky because I can keep records of everything and I can track everything. Not everybody understands the system. Not everybody understands how the system works. But there is always a King Solomon somewhere that we have to find to help us. And that's what I'm trying to do. I'm trying to find the King Solomon, and I've been helped several times by a King Solomon in the court system since this started. I just don't know who it is.
I understand that. So now you've delved into learning more about family law because you've been thrown into it at this point. So now you're writing your own motions. You're going in as a pro se litigant, and you're seeing it for what it really is. And
yes.
And where does this take you?
Listen, as an attorney, I would always tell my clients, if you could settle, settle. It's always a better resolution. But this is an impossible situation. And it's also impossible for the judges because it's very hard for them to tell also what the truth is and what's going on here.
Yeah, when you have this monkey show going on. But one of the main issues here, and one of the things that I stand up for, and I work with experts in the field regarding ADA accommodations, ADA violations, that would be American Disability Act. I've personally found that, and this is national, I've personally found that under the ADA, it's violated all the time. It's violated all the way up to the Department of Justice. One of the things that a lot of people don't know is that even if you're not diagnosed with a disability, your ADA is violated the second they take your children from you. It is the most traumatic, horrible thing you could do to a human being, to the children and to that parent, by literally severing their ties and then causing all this other type of havoc. But you, in your particular case, you actually have a diagnosed
Yes.
disability, which did you tell the
I have dyslexia, and I was diagnosed in college. I took Spanish. I studied, and I failed with an F.
With an F.
And the teacher was a very nice woman, sent me for testing, and I came back with severe dyslexia, and I was entitled to a note taker in class and untimed exams, and even an untimed bar exam.
And in your case, they are accommodating you in the court with an ADA advocate or not?
There is no ADA advocate, but they have entitled me to take in a note taker. But one of the problems that I'm seeing is even with the note taker, the transcripts are so poor that so much of it's inaudible. Okay. And supposedly, and Mark can speak to this more, there's a CART digital system in the courts that we're not getting access to.
Okay, because part of the ADA accommodations that the courts are ignoring throughout the country is the fact that you're actually supposed to have somebody there even for moral support. It's a very high stressed place, the court. Most people can't even go one time to court, let alone repeatedly having to go back to court as a parent, fighting over your most precious thing in the world.
Well, the last time I was in court, they actually closed the courtroom, and I had brought a supervised visitation coach with me to court, and she was sitting with me outside the courtroom, and she was told she wasn't allowed to come in.
Yeah, and this is something. These are more violations, and you're obviously as an attorney, your due process has been violated repeatedly. Yes. Did you want to touch on that a little bit, and then I wanted to talk a little bit about this wonderful lady right here.
Well, I currently have pending an order to show cause in the appellate division to transfer to another county, because I've already had 2 judges recused, and I just had an order issued by the current judge, who states, yes, visitation is in effect, but I need to arrange it with the children. And after all this time, the children don't want to speak to me, so it's almost impossible to arrange visitation. So I'm going in this cycle where I haven't seen the children for 2 years on a visit.
You haven't seen them in 2 years at all, not even supervised?
No, I've seen them. I stopped going with supervising because the woman who was doing the supervised visitation wouldn't give me a schedule, and she was also ripping me up.
And then they charge you?
No, but it wasn't just the money. She was not
scheduling.
No. It was a little more complicated than that. She actually was overcharging me and not crediting me properly. And there was no schedule because my ex-husband would never agree to a schedule, because he was trying to make the visits longer and longer in between. Like, I wanted every Thursday for dinner. No, he wouldn't agree to that. And he would schedule the children's activities to conflict. As soon as she gave him a schedule, he would make sure they were scheduled so they couldn't come. And everything was put first before me.
It's just...
We tried therapeutic visitation. We were supposed to go at least once a week. It was maybe once or twice a month if I was lucky.
And then have you seen, I know it's been not as frequent because of the visits, but have you seen a deterioration in your children? Do you notice an emotional
Absolutely, they
change
won't speak to
them?
me anymore.
And this is called Stockholm Syndrome.
Yes.
Because they believe that you don't want them, or they believe whatever lies they're being taught. They're all being told different things. So it's what brings about the Stockholm Syndrome, which I believe is reversible. But one of the main things of raising public awareness on this horrific system that we have in our country is bringing to light the truth about what's happening to people. Bringing to light the fact that right now you're a perfect example of having your children separated from your life. We understand that there are horrendous damaging effects to both parties. that are irreparable.
Yes.
Okay, we have the ACE study, which is adverse childhood experiences. That's the number one largest medical study ever conducted by the Department of Justice that fails to effectuate the change needed, that fails to honor that medical study. It's affiliated with, or it's incorporated in our Supreme Court, and yet the lesser court, the family court, completely violates it. And so here's your...
The family court doesn't really have the checks and balances that the other courts have. Like if you get a decision from a magistrate, you can't even appeal it. You can only go to the OCA.
Talk about that to people that don't understand that language.
Okay, so in New York State, we have magistrates. Magistrates have been appointed, but they're not elected. So they fall in a different category than a judge who has been elected. They fall under the Office of Court Administration, which is supervised by Lawrence Marks. And so you can't appeal anything that the magistrate issues. So it's a very gray area. They can say and do whatever they want. They can recommend you go to jail. They can take your children away, whatever they are recommending. And then there's no... It has to go to the honorable judge who's overseeing that particular magistrate. And by the time it comes down the pike, so if the magistrate makes a decision, the judge will probably take 2 to 3 months to schedule a confirmation hearing on it. And then she or he may take another 2 to 3 months to issue a decision. So now almost a year has gone by and you are unable to appeal anything. So that's a big problem with the magistrates. They're given a tremendous amount of power and very little checks on their power.
Very little accountability. No accountability, actually. I don't really see much.
Well, there is some from the Office of Court Administration. They are trying to work on it. But however, you know, there's so many different family courts, and each one is their own little fiefdom.
And all these complaints, this is something that I see a lot. All of these complaints that come up from parents, when it does reach higher courts, appeals, and so on, they literally poo-poo this, and I've heard them say this as, oh, they're just not happy with the outcome of their case. And they literally degrade it to that instead of actually going through the briefs. I don't believe they go through the briefs with a fine tooth comb. I think they literally... I don't believe they...
Well, you know what? I have to say, as an attorney, I have to believe in the justice system. But part of it is you have people like law guardians or the Office for the Attorneys for the Children, and they come in and they make these statements that are biased or not backed up, and then the appellate court goes with them because they feel that they should defer to the lower court because the lower court actually heard the evidence.
A good point to know. It's a good point to know. Okay. And so as an attorney, how would you help all these countless people that are out there in how they would approach this?
My father has a theory in life that he taught me, and I see that it works over time. If you throw enough shit against the wall, it's going to stick.
Yeah, it's true. That's a good point.
So the one good part about family court is it's very easy to file a petition.
Yeah, too easy.
Too easy. You can file every week a new petition.
Frivolous litigation.
You can bring the other party to court every day.
Yes, you can.
You choose to.
They love it when you do that. The more chaos, the more money for the court.
So, but eventually, if you keep doing this, the truth will come out because it does rise out. You know, after a certain point, somebody's going to pay attention to the fact that these people have been in the courthouse 30 times and there's still no resolution. But the
30 times in a month, times 10 years.
But the other thing is there are supervising personnel above the family court. And there's a supervising judge for every family court district, and you can reach out and contact them directly. Above the family court supervising judge, there is a supervising judge for the judicial district, and above them is the Office of Court Administration. And all these people are tasked. Right. So unfortunately, it takes a lot of time and effort, but there is a King Solomon out there for you to find.
So do you feel being victimized by the court system as an attorney, but going in pro se, do you feel that the court is just and fair?
Not at this moment.
Okay, that was my main thing. Is there anything you want to add to this? or tell the viewers.
As I've been trying to see my children for 2 years, and I haven't had visits. I haven't been able to schedule visits. I was supposed to have summer vacation, and the judge has directed me to schedule it with the children, which is almost impossible because the children aren't speaking to me. So the problem is people need to learn the underlying laws. And a lot of our judges have been elected. They haven't come up through the ranks. They haven't learned the family system. And the other problem in the U.S. is the family court is looked upon as a low court. And that is a problem because this is our families. These are our children. This is our next generation. And we should not be putting this as our lowest priority. It's like our teachers. Mm-hmm. We say about teachers, those who can't do teach. And that's the wrong attitude. And that's why we're falling behind, because we're not putting the children first. We're not putting the family first. And that's what we need to do. We need to make the family court a good place to be a judge, not a place to be punished or set.
Punished for protecting.
Yes.
Punished for protecting your rights, your children, your life, everything about your life. I agree with that. Personally, I feel that they need to be abolished completely and started over. That's my personal opinion.
But they've done that in New York. They got rid of the law guardian system and they switched over to the office for the attorneys for the children.
Right.
And it's made no difference.
In 2009, but
it made no difference.
Under the age called an infant in law up until they're 18.
Correct.
Having their own attorney, having you taken out of their life, and a child goes before somebody who they don't know. It's not only offensive, it's completely uncomfortable. It's putting a child on the spot. I do not see any psychology that would support that in any way, shape, or form, that is in any way healthy for a child.
It's just
it's a way to make parental bond.
It's a way to make money for the attorneys.
It's absolutely despicable. And yet they have CPS, child predator services, that go into schools, and a child doesn't need, they're supposed to by law, but the schools are not informed. So they go into the schools, CPS, and they question your child, interrogate your child, take your child separately into another room without anybody there to support that child. What's the child going to say? What is the child going to do? And there has been so many studies done where if you ask a child the same question over and over again, they'll give you a different answer. So we're making adults out of our children, and we're literally using them as pawn, and we're destroying everything about them. We're robbing them of their innocence.
And they're so manipulated.
It's beyond the system. The system's
horrible. So they tried to revamp it in 2009 when they got rid of this, because what was happening then is the law guardians could say and do whatever they want.
And they are.
And now, actually, the laws have changed. They're supposed to be reporting what the children said to them, not any of their feelings. And that's not how it is. Mm-hmm. They're still making decisions.
Even if they report what the children say, though, again, I'm going to take a child's words with a grain of salt.
Well, the studies
is daddy good to you? Yeah. Daddy's beating you up in the corner. Is mommy good to you? Oh yeah, because mom will beat me if I say different. So you know what I'm saying? This is not.
But also, these
unethical.
Attorneys for the children are making decisions. When I was sitting in family court one day, which I consider purgatory.
I consider it hell. But go ahead.
No, it's purgatory because it's not hell. Because there's no end in sight.
It's true. You're not getting out.
He lost his children because he lost his job. They were in a
like
shelter.
Kicking you when you're down.
And he wanted to see his children 3 times a week. And the attorney for the children said, "No, I don't think that's right. I think once a week should be sufficient." And his attorney was like, "Well, why? We want to reunite the family. We want to bring them together. No, it's too disruptive to the children. They're in foster care right now, and when the parents walk in, it's confusing." That's
confusing. Not the fact that there were strangers that
and I'm listening to, and the guy is almost crying. He's like, "We've got the rent money together. We got help. We're gonna hopefully get them back within a month." Yeah. Like, why are we doing this?
Right. Why are we doing
this? And he followed all the rules. And that's the thing. There's New York State really needs to put in a pattern, a path. New Jersey has a pattern or a path. Other states have a pattern or path for you to come out of the situation. Okay, so you were put in unfairly. All right, life isn't fair. It sucks. But you need to know, okay, so this has happened to me, but how do I go about getting out of this? And there's no guidance in New York.
How about this? Stay the hell out of our families. That's how you get out of it. That's my opinion.
True.
And I'm right. But we have this lovely lady here. Do you want to talk a little bit about her and what happened here? Because first of all,
so what happened is my
lied.
ex-husband has now stated that the children don't want to see me at all.
Right.
So whenever I get an opportunity that I find out that the kids are at a game or something, I try to go. And I actually brought with me MSW. She's a supervising visitation coach. But I was not in supervised visitation at the time, but I've seen so much damage in my family that I'm reaching out for anybody who can help me. I'm building an army of assistants, therapists, different therapists that we've dealt with, different people for support, and also different people that I can go to guidance, because I'm not a family law practitioner. So she came to me at the game, and my daughter came over to me, gave me a high five, had a smile on her face.
She doesn't like you though, and doesn't.
And the father pulled her away as quickly as he could. Yeah. The interaction
he didn't
lasted.
want anybody to see that in the public.
Right. The interaction lasted less than 2 minutes. Before the game ended, he had packed up his stuff. His car was right there. He pulled into the car as soon as possible. But he didn't know that I had this woman with me, and she actually wrote a report to the court contradicting everything that's been said and done. But what I don't understand is, even with all the documentation that was provided to the court, nobody's had a hearing.
So this is where I put all the blame on the judges. And I know, you have your respect for the judicial system, and I used to years ago. I can't any longer. Like I said, I do this on a national and global level. So I know way too much to say that an apple's an orange. But here's where the judge is wrong. I mean, how much more do you need to assess a room and to look at the situation and dynamics of a family to say that what you're doing is okay? With the studies, with the social science research.
I think more education.
With the borders right now.
But more than anything else, I think that there needs to be more education of the judges.
So you don't think that draining them from hellfire is not part of the problem?
No, I don't think that's going to work in the long run, because we have to have some sort of system here. We can't just throw our hands up and hope that everybody's going to play nice and get along. It's not going to work. But I think education is the way to go. I know that, I practice in landlord-tenant court, and I know that those judges go to a 2-week seminar every year. I don't see that going on in the family court.
That's a perfect point, because no matter what position you take in life, no matter what job you get, even if you're working for a fast food restaurant, there's going to be health and safety. There's going to be, there's all kinds of checks and balances, but not in the family court.
Correct, and we need to see more of that.
The most important, most precious commodity in the world is children. I hate to say commodity, but I don't know how else to put it. I mean, what greater value? But
it's our future, and we're not protecting the future.
American future.
And when you look at the American future compared to other countries, we are going down.
Where?
And most other countries don't have this situation with the legal system. You pay to play. You can't just running into the court. And you know what? Part of the problem is that our system is so overwhelmed.
Billions of dollars.
But it's also overwhelmed our system. Our judicial system wasn't set up to handle the number of cases. There's some judges who literally just dismiss, because they got to clear their dockets. They just can't handle the number. So maybe if we changed our system, I know in Germany, if you're going to sue somebody, you have to be sure to be able to come up with the money at the end if you lose.
I know that in the UK and in Australia and New Zealand, they have actually tripled the amount of problems that we have in the family court and CPS. It is a multi-billion-dollar industry, and it is actually child trafficking kids. Literally to the point of sex child trafficking, and that's what's been infiltrated through CPS and foster care and forced adoption. Family court being the precedence that's catapulting it into that position. A lot of people think that child trafficking is just about sex abuse of children, but when you're moving children and you're disrupting their biological homes, and you're not bringing in intact how to handle when there are real issues, and you're just throwing kids around like this, it's a form of child trafficking. And so personally, I just don't see I don't see anything happening, but it literally being completely built up from the bottom up again. Whether that be mediation, whether that be being treated like respected human beings, parents, rather than walking in like you're two criminals, and then I'm going to just decide your fate in 5 minutes. I'm not going to look at evidence. Do you feel like your evidence was ever presented to a judge in a
Not all
manner?
of it, no.
So
But I try. I try. Even when I speak in the courtroom, my ex-husband is getting double the time that I'm getting.
Yeah, and that's something that we see a lot too. We see there's been just a lot of different things. Sometimes it's completely anti-dad, sometimes it's completely anti-mom. Who's paying the judge? We see a lot of that. A lot of times there's family court is held without another parent knowing about it. They just literally have court, and then when you go in to say I was never served, which is what happened in my case, nobody goes to court for 10 years straight and then just doesn't show up.
No.
But we're seeing a lot of that right now, and then they just switch custody. I mean, obviously, I had more behind mine because I was personally giving the Judicial Committee over 70 cases of child abuse about the judge that I literally court watched yesterday, Anthony McGinty, which I like to say his name a lot. And again, no accountability. But I have seen a lot of cases now through the appellate court where they are saying that the judge did wrong. I'm seeing a lot more of that. I don't know if you are, but I'm seeing
what I've done is I've actually researched every case. The current judge that I'm assigned to is a brand new judge. She actually completed judicial school in January.
Okay. Now, tell us about judicial school. What do you know about judicial school?
I think it's 4 days.
4 days?
Yes.
Did you guys hear that? 4
Maybe it's 2
days.
weeks. Please don't quote me on it, but I know that it was reported in the New York Times that she went to judicial school.
Wow, we need to look up that. We'll need to look up that. So
it was in the New York Times article.
So that's less than a quote-unquote caseworker for CPS.
I don't know what a caseworker is.
They get a 6-week program, I believe. But don't quote me on that one. I'll go back
I think we need to confirm.
It's all bad. I know that.
What the judges
get. It's pathetic.
But yes, judges have to go to some short judicial school because unfortunately our judges are elected.
Right. Or they run unopposed.
But
what happens when they run unopposed and we don't want them?
But they're elected. They're not
right.
They're not appointed as in the federal court.
Right. And what's good about that, and I'm going to put this little plug in for governor for New York. What's good about that is they can be unelected. They could be recalled, which is my goal. Okay? You got to go through all of them and say, this one did this to who? Oh, you're not going to be there anymore. But anyway. So did you want to say who she was, though? Or she's a supervising visitation coach.
Yes, and her name is Durla Weller, and she was
Durla
Weller, and she was fabulous, and she believes in reuniting families.
Yeah, which is what we need to do.
And that's her focus. She's not just out to have supervised visitation. She wants to reunite the family because she believes that the children are what matters. Look, I'm going to walk away. My ex-husband's going to walk away. We're going to grow up. We have our lives. But these children are impacted forever from what's happened to them.
Now, we have, just to show on the screen, if we could, just a few different judges. The one here that I have is Judge Shower.
That's Mark's judge.
That's Mark's judge. And then we have a host of different judges here that you've been through that literally you've gotten them all to recuse themselves, which that's great. I only got one judge to recuse my case. Well, mine and a bunch of other cases. So I was proud of that because that's even though our laws are very, very clear that if there's bias, they're supposed to come off the case, but they think they have exclusive rights, which they don't technically, but we've been lied to. But you were able to get how many judges to recuse?
2 already.
That's badass. Okay, you get the award.
I don't want the award. I really and I just wrote a letter to the supervising judge for Westchester County Family Court. Really, all I'm looking for is a relationship with my children. Yeah, that's all I'm trying to do. This is never what I wanted to do. No, this is never what I set out to do. This is taking a tremendous amount of my life. And this isn't the way it should be.
It's not the way it should be.
I should be able to go to the pool with my children on a summer's day.
You should be able to be a mother to your children, period. And God-given right. You're their mother, period. There's no other ifs, ands, or buts about it.
Their stepmother is there, but I'm not. And I'm completely excluded. The bar mitzvahs, anything. I'm not part of the family. I've been written out. And it's sad. It's sad for the children because they then lose half their family. Their family is no longer what they thought they had. So I'm going to do my best to see my children. If I have to get another judge recused, I will. I currently have a order to show cause pending in the appellate division right now to transfer to another county. But I don't know if that's going to be any better.
And we're going to interview you when you're in that other county if that happens, because I would like to see if they do any better. And unfortunately, it's difficult
but this
to
is
say.
a very simple
I'm
matter.
hopeful.
The case law states that the non-custodial parent should be able to have a significant relationship with the child. And I actually brought the cases with me today that state that. And they also state that it is not appropriate to allow the child or the parents to do the scheduling. That is the court's responsibility to step in and do the scheduling.
When the parent's not doing it.
Here, the cases clearly state. Oh, I highlighted one set. Sorry. Here's my highlighted set. Like here, the case is Supreme Court Appellate Division case, 4th Department. Guy versus Guy. The presumption that the custodial parent will be granted visitation may be rebutted when it's shown only by a preponderance of evidence that visitation would be harmful to the children.
Right.
And nobody's shown that.
No.
Here, the children are in this case, Ronald C. versus Sherry B. There's a presumption that the father should have child visitation, but the children supposedly didn't want to have visitation, and that's the Stockholm situation again.
Yeah.
And it doesn't matter. The court has ruled, but at this point, the father has lost a year of visitation.
Right.
Going through and trying to get time. In this one, here, the attorney for the child hadn't violated its ethical duty to determine the child's position and advocate zealously in support of the child's wishes.
This is a good one. This one is Kleinbach versus
Cullerton.
And this is actually substantial evidence that
the father's visitation was detrimental to the child, did not exist. And the attorney for the child violated his ethical duty to determine the child's position.
Okay, so this is a very important one for people to look up, which is
so these are all very important cases,
Cullerton.
actually.
Yeah, Kleinbach versus Cullerton, because
you can post that on your website.
Yeah, this is excellent. This would be against the attorney for the child that violated their ethical duty to determine the child's position. We're seeing a lot of this, and I think that we all should go after this completely. I think we all should use this. Because these child attorneys and guardian ad litem, they are speaking for the children in order to move the cases in the favor of one party or the other versus then keeping families intact. And this is a big issue, and this is what everybody can agree on.
And this is a family court in the Bronx. Well, an order of visitation is always conditioned upon a consideration of the best interests of the children. Denying visitation to a biological parent is a drastic remedy. Should only be done when there are compelling reasons and substantial evidence that such visitation is detrimental to the child's welfare.
And on that note, too, on this one, when we have genuine cases of abuse, children are being abused one way or another. Children are someone's drinking and driving, doing drugs, physical assaults, repeated orders of protection that are genuine. These courts do not care. They do not care. Okay, they'll separate good families. They'll separate good, healthy parents. And when there is genuine abuse, okay, they do not care. When there are issues that can be worked out, something that someone did that can be worked out, these courts do not do anything. They just want to get these children into adoption is really what their goal is. But
and then the family court has broad discretion in fashioning an appropriate visitation schedule that promotes the child's best interests.
I don't agree with the child's best interest at all. It's one of the fakest
Right. So what does that mean?
This is very general, and this is giving way too much discretion to these judges, and that's why they're rendering these messy decisions. That's why we're here exposing this garbage, because this has to stop.
But that's what I wanted to say is what is this best interest? There's no definition.
No,
it's not. You can't go to Black's Law Dictionary and pull out what is best interest.
Right.
It always goes back to Esserbeth versus Esserbeth. The broadness just. And it's horrible because the judge, but also, the judges are put in a position where they don't know what to do either. And they have so many cases.
I don't agree with that, but go ahead. If you're a human being and you have a brain in your head, okay, here's what I say. They enter the family court, these judges, brain comes out at the door, heart comes out at the door. They pick it up on the way out, maybe. They know better. You cannot look at families and think that this is okay.
But that's part of
And
the
go to sleep
problem.
at night.
Nobody's looking at the full picture.
But how hard is it? You're sitting there in a court of law. You're a judge. You went to school for a whole
But
4 days. Come on.
Well,
And
it may be more than 4 days, but it's not 6 weeks.
Right.
But the thing is, we need to change our system so that the court can actually look at the full picture of the family. They're hearing from one attorney. They're hearing from another attorney. They're hearing from somebody who met with the children for 15 minutes.
Nobody knows the children, right?
So how is the real truth coming out?
How is the real truth going to come out when they're speaking on behalf of a human being and that human being is not there?
But even when they bring them in for the in-camera,
when they do
they bring the law guardian with them. And some of these law guardians are biased. Some of these law guardians have already told the children, this is how you're going to answer it. Or the other parent has prepped the children. And coming in and speaking to the judge. Judge is not a psychologist. You need a psychologist or a therapist to come in and speak to the children.
We're going to go on a quick intermission right now. My book, best-selling book, Punished for Protecting the Injustice System of Family Court. I want to remind everybody that Punished for Protecting stands for fathers and mothers, biological families, grandparents, aunts, uncles, cousins, everybody. No one should be taken away from children unless there's genuine danger. However, this is my true story, so it's about moms. So we'll come back after this, and we're going to talk to Mark Fishman.
Thank you.
We are back.
So we are back now, and I am with my next guest, which is Mark Fishman.
Nice to meet you.
Nice to meet you too. We're continuing to deal with Westchester County.
We are.
You're dealing with the Yonkers Court, is that right? Yonkers Family Court, or?
I'm actually in all three.
You're in all three.
They have my case separated in all three courts, yes, because they all consider Westchester Court to be one court with 3 branches: White Plains, Yonkers, and New Rochelle.
New Rochelle. So in this particular case, this is a genuine ADA violation, ADA, American Disability Act case. Why don't you elaborate a little bit and tell our audience what's happening in your case, or what's been happening?
Sure. If you're disabled, and if you're in family court in New York State, or especially Westchester County, the odds are against you. There's no way you're going to proceed to a resolution or conclusion that is timely, or as you stated, that complies with the ADA or the Rehabilitation Act. The family court punishes you if you're disabled.
I personally feel like the family court punishes everybody. I've said this over and over, and I'm going to say it again now. They give you a disability when they take your children from you. That's automatic. It's instantly something that happens in the brain. It causes traumas, and ACEs proves it over and over again. In your particular case, though, you have a brain injury, or can you tell the audience a little bit about that, and then what they did to you when you filed your lawsuit?
Yes. So family court, I agree with you. It needs to be changed. Needs substantial rehabilitation. Once you're disabled, like me and thousands of others, particularly what's called invisible disability, you don't have a cane or wheelchair.
Yeah.
You in essence have to fight the system to state you're disabled to get reasonable accommodations. And in my case, I have disability discriminating Judge Shower, who kept me in court for over 4 years. Over 4 years, just recently read the decision. And the only reason she issued a final decision is because we're suing the Office of Court Administration. We're suing Judge Shower in federal court.
Good.
You know, there needs to be finality. There needs to be reasonable accommodations. But to answer your first question, I was in 2 horrific car accidents back in 2013, dropping off my kids at New Rochelle Elementary School, and I was hit by a bus. By a school bus on a drop-off line. And
were the kids in the car?
I had 2 kids in the car. Thankfully, they were not hurt. 2 of my 4 beautiful kids. But I suffered what's called a septal neuralgia, which is 7 nerves in the back left side of my head, as well as what's now known as traumatic brain injury, as well as a broken toe, bursitis, and tinnitus, as well as burning eyes that come from these nerve injuries. And because they were invisible, and because I've had 3 implants, 2 neurostimulators, and a metal hip, the judges look at you like, oh, what's wrong with you?
Right.
We don't have to accommodate. So my case that began in June of 14, which would have been over if you didn't have disabilities, was delayed more than 4 times by disability discriminating Judge Shower, who refused to take the trial, constantly allowed more charges by my ex-wife, constantly wanted more therapy, more social worker. Having had over 780 psychological, neuropsych, psychiatric, social worker, parent therapy, parent classes, and all said I was an excellent dad and should have unsupervised visitation. And a disability discriminating Judge Shower says, I don't care. And finally issued her order after I was determined to be unfounded back in August of 14. No abuse ever happened.
Right.
Okay, to say no, she felt I abused my youngest son, who also was disabled, and that I should have permanent order of supervision. And during this process, has every year taken away more and more of my civil rights. She even jailed me back last year for sending gifts to my kids.
Yeah, I remember that Elizabeth had told me that she jailed you for sending gifts to your children, in which we see a lot of this.
If you can imagine, so
yeah, I see it all the time, and it's when any normal, rational person hears this. Okay, and again, I have to put it back on the judges again. How you could arrest somebody for giving your children gifts? It's like saying, I gave you life. You breathe in and you breathe out. Here's gifts. None of those things are criminal.
But I didn't say arrested, mister. So let me be clear. I was not arrested. The police and the DA did not prosecute. Judge Shower issued an order. But unlike my friend Elizabeth, I was denied a note-taker in court. So there is no stenographer. Okay. Our courtrooms do not comply with ADA. If you have a traumatic brain injury, as I do, you need to remember, I was denied my aid. I was denied an assistant. I was denied a note-taker with constant requests for accommodation. You don't need it. Take your own notes. Attorney, take your notes.
And that's one of the things I wanted to touch on, because you first started a lawsuit and they denied it, saying just get therapy. Is that correct? Did I have that right?
My ex sued no different than thousands of other exes with false charges. She said mental instability. She said larceny. You stole $50,000. Was never alone with her for the previous 2 years. Always in Supreme Court. So how I stole $50,000. Okay, and committed these. Some sort of child abuse, okay?
But no proof of anything.
Child abuse, CPS, and ACS came out within 6 weeks and said, unfounded, cleared. The judge says, I don't care. They order one of these so-called psychological reports. Right. You don't do a psychological report of someone who has traumatic brain injury. You have to footnote that you have a memory problem. You have dementia, Alzheimer's. Right. No, they label it as narcissistic personality disorder. Wow. I'm very charitable.
How does a judge know what's a narcissist? And they look in the mirror?
They don't know what it is. They get a 29-page report and they get scared. Right. Oh my God, something wrong with somebody.
Yeah.
But was it someone who has an expertise on traumatic brain injury?
Right.
Am I remembering?
Right.
So fortunately, I have lots of doctors, very good doctors, who said, no, I've seen him for years before this.
Right.
He doesn't meet the qualifications for narcissistic personality disorder. Very charitable, very giving. The kids love him. They want to be with him. This is not this. But once you get the label, the judge says, okay, do another psychological report. She doesn't like these reports. They don't allow it in. So at our final trial, the judge didn't allow any of these reports. She refused to allow a neuropsychologist to testify about traumatic brain injury. She says, you know what? I don't have to accommodate you. This is disability discriminating Judge Shower because you're not disabled. You're just crazy. So,
oh my gosh.
Before my sentencing hearing, where I was sent to jail a year ago on June 27th, we actually had a neuropsychologist from Columbia University ready to testify in court to say he has traumatic brain injury,
Right.
he has sleep apnea, he has TMJ, he has nerve injuries, he doesn't remember like your normal person,
Right.
and he needs accommodations.
Right.
No. Okay, I gave an order. It said he can only send gifts on major holidays and birthdays. But I told him in my order of protection in court that day during our 8-hour hearing, okay, that Mr. Fisher, there are no holidays between March and July of 2017. There are no birthdays. Well, 2 of my twins' birthdays is in July. The judge can't recreate that law. But she said Passover, Easter, and July 4th were not major holidays. I grew up in a house where those are major holidays. We give chocolates to our kids. We give gifts on holidays. And so she sent me to jail. She says I willfully violated it. And honestly,
so you went from the court directly to the jail.
Went from the court. The judge.
Rights were not read.
Right. There was no arrest.
No actual arrest.
This is a confinement.
Familiar. You have to read my book.
This is confinement. This is not. This is not a criminal record. So she did this willfully. She did this willfully.
Yeah.
And knowing I had this ability. So I followed the order. The order said I can only send gifts to major holidays. I said, Mr. Fisher, those might be major holidays in your crazy family, labeling my family. Okay. But for the rest of us normal people, these are not holidays. I told you no gifts. You said
Passover is not a holiday?
That's what she said. Disability discriminating Judge Shower.
We got to set her loose.
Disability discriminating Judge Shower thinks she can rewrite the federal and state calendar.
I am blown away.
So I went to jail, and with these disabilities.
You're looking at her. Is this her on the screen? You're looking at her.
There she is. Disability discriminating Judge Shower.
This woman right here, am I pointing correctly?
Unfit
does not believe that Passover is a holiday. Okay? She doesn't believe that Passover is a holiday.
Neither is Easter. Neither
is Easter. Neither is Easter. Neither is the 4th of July.
And with traumatic brain injury, you want to be very clear, and you want simplistic orders. My orders were half a centimeter size.
Yeah.
They don't even meet the federal definition, where at least you get 12-point print. Okay? And if you wanted an order that said, don't send gifts, you know what? You and I, we speak English. Just put an order and don't send gifts. No, you can always send gifts on major holidays.
Listen.
You abused it. How did I abuse it? I followed an order.
These judges are telling people, okay, years ago we had photo albums. Now we have Facebook. This is your First Amendment right, and they're telling them they can't put their children's pictures up on Facebook. But they're only seeing them here and there. They're only getting them for 5 minutes here and there. And it's part of the little bit of minuscule enjoyment they have with their children is to post it on Facebook so they can get that accolade of joy with the world and their friends and showing their children. How dare they, these judges, tell you can't put your children's pictures up, Judge Gucci, up on Facebook or any other judges out there. You're disgraced. Or telling you that you can't give your children presents. That makes you a criminal or a bad person. So you're doing what comes naturally. This is what we call God-given rights. Okay, whether you believe in God or not, it's what there's no other way to pull that. They're your God-given rights, and yet these judges are going to tell you today you can breathe, tomorrow you can't. Today you can sneeze, tomorrow you can't. I mean, this is what they're doing.
It's absolutely horrible. So Judge Shower's punishment, and again, we have to say punishment, because when you go to jail for confinement,
it's punishment.
It's not a criminal conviction. Okay? I still cannot send gifts now since that order. I cannot call my kids. I cannot get my school records. I cannot visit them at school. I have to see them with a social worker because the judge says that you're crazy. Without
a judge. Now, let's talk about that for a minute, though. This judge has no legal right, no right whatsoever to diagnose you.
Correct. And she wouldn't allow any medical expert. One psychologist that I've seen for years want to testify.
We'll keep this one up on the screen.
You cannot testify to his medical condition because he didn't do a 19 psychological report.
Unbelievable.
I said 19? What about the other 18? No. Well, you didn't file a court order. How many reports do we have to do? If you would have a neuropsychologist come in or someone that specializes in brain injury, hey, he has low dementia. He has a hard time finding. What I do, I send gifts to my kids. Why is this a crime? Why were they deprived? And they don't even know.
How long did you?
I was in jail for a 3-week sentence. The warden let me out after 2 weeks. I was in a jail hospital. Couldn't go outside. Didn't have regular freedoms. And
can anybody get to you right away, or were you able to get on the phone right away, or anything like that? Or did they
had very, very limited pursuit. I was in a hospital and I was in a room with a murderer.
Because I know they'll do like 74
with a murderer who murdered 2 people. With a pedophile.
That's
okay.
Lovely.
And this is how they want reform. This is how they want reform.
This is not a reformable
system. This is about punishment. This is not. You don't jail people or say you accommodate them. If I would have had a note taker, or if there would have been a stenographer or a transcript system where you could actually see the transcripts. Okay, this one happened. And see, this is where my friend Elizabeth, nailed the nail on the hammer. Okay, the courts under Governor Cuomo, okay, in 2015, a mandate to have this CART system. And then for people with cognitive disabilities like myself are hearing. And basically what it does, it's no different than, let's say you're on a TV show Jeopardy. It poses the question on the screen in front of you so you can see it, you can read it. Yeah. We remember it better. Right. When you deny us note takers and other things, we need memory aids. Right. This judge denied me a note taker, saying I didn't need it, saying I should remember myself. And then when we ordered transcripts, she would then hold the transcripts up for 3, 4, 5 months. Wouldn't even get them. I had to send, for one of my appeals, I had to contact the Inspector General, who had to walk in someone to get the digital recordings, to get transcripts, because the appeal wouldn't have been heard.
I'm working on a case I've been with since 2014 with Lori and Brian Tracy. You can look it up. And they're holding back Rockland County Court is holding back their transcripts as we speak, and took their child because they're learning disabled, high functioning learning disabled. So we're in the middle. We've been in the middle of that one, but this is what we see now. You obviously, I'm assuming you collect disability.
No,
you don't.
No. I've tried to be fully functioning. I've tried to do what you're blessed with, is that you try to get yourself back on your feet. My father has a Horatio Alger story where he was born with a defective leg that was 8 inches long and others. So we've constantly been in hospitals, and we've constantly had surgeries and taught ourselves to get back up on your feet. This is how I was raised. My father had over 100 operations by the time he was 14. During family court, I've had 11. I have my neurostimulator on the left. Instead of taking opioids, this does electric stimulation, goes right up the neck, goes in the head, and so I don't experience pain.
That's awesome.
This neurostimulator works so well. I had a problem sleeping, so I have a neurostimulator on the right, and this one opens my throat up and pushes my tongue forward so I can breathe. And I have a metal hip. Okay, so but why does this make me an unfit father? Right. I did what you should do. I knew that opioids were dangerous. Get off them. I got off them after 6 months. I got a neurostimulator. It works. Oh no. There's something wrong with you. You have electric. Something wrong with you?
Wow.
So no, I've tried to provide for my kids. I've worked through constantly, tried in between over 100 court sessions, a myriad of judges, still in family court in different parts. And the problem we have in family court is that in addition to everything your show mentions, yes, it is rigged. The system is total form. If you're disabled, they don't accommodate you. They don't think they have to. They just want to label you. And what is wrong with a reasonable accommodation? I had to hire. What is wrong with your client? Excuse me, my client's disabled. He makes that up. Okay. Wow. What's he paying you all this money for? Okay. And, it shouldn't have to be this way. Yeah. A doctor wrote saying, look, he's experiencing heavy symptoms of sleep apnea. I once fell asleep in the court. And this is August of 2017. And we asked for an adjournment. I'm not going to give adjournment. She just says, you know what? You continue coming here. You take a walk around the court. And he's saying, why can't we have only sessions? No. You know what? He can come in the afternoon. I don't care. I don't have to come in. He's not disabled.
So let's talk about, you wrote a federal action against the judge Shower.
Discriminating judge, Michelle Shower.
Right in
Yonkers.
Right here. Yep. Oh, wrong way. That way. This judge right here, Shower. Talk about that.
Right. So basically, my trial ended in mid-September 2017, and the judge just issued an order. But as Elizabeth mentioned, my friend, that there's no accountability. So the judge just wouldn't issue an order, and we were going on over 6 months. Where's an order? Oh, we'll get one. You'll get down it. In family court in New York, if you're in Article 6 or 8, you have no right to appeal. Okay, a denial of an ADA accommodation or appeal anything, interim case without a final order. Discriminating Judge Shower willfully refused to issue a final order.
That's what they do.
Finally sued in federal court, brought Office of Court Administration in, who says the parent organization, to say, where is this man's order? And we pointed out, under federal law, every government is supposed to have a grievance procedure for a government that has over 50 employees. New York State has none. So a grievance procedure is supposed to be prompt, meaning 30 to 45 days, timely, and it's supposed to be handled by people experienced in ADA accommodation, ADA law.
Biggest problem we have.
Biggest problem we have. But every other state has a grievance procedure. You write in Colorado, you get a response back. In California, you get a response back. And then it gets adjudicated within a month and a half max. Okay, and normally the accommodation is granted. In New York, no. File an appeal to the appellate division. That's not a grievance, because an appeal to the appellate division in the second department is backed up 3 to 4 years. But here's the problem. Then your grievance is public. Under ADA accommodations, your medical information is supposed to be private. The grievance, your ex-wife and the children's attorney can oppose your grievance and say, you're not crazy, you don't need accommodations. That violates Title II of the ADA. There's not supposed to be an adversarial process. The government's supposed to grant the accommodation if you're disabled. So they make it adversarial, and then, we don't have to accommodate. So to this day, we got an appellate division decision actually a couple weeks ago denying me the ADA accommodation, say the Judge Shower, disability discriminating Judge Shower, was right to deny the accommodation, deny the note taker, and right to jail me, and that I did not prove I was disabled. I didn't prove I was disabled. Over 8,000 pages of certified records have sent to the court that they have asked for my financial records and medical, showing disability, showing 11 surgeries, 3 implants, but I'm not disabled. Why? Because I don't have a cane or a wheelchair.
Right.
So if I can't get labeled disabled, what happens to one in the homeless shelter?
But wait a minute then. Let's think about the contradiction here. They can take Lori and Brian Tracy's children for being learning disabled, but you're not disabled with 11 surgeries and all these expert documentation that you are.
Right. And
so isn't that a contradiction to the...
Not only is it a contradiction, but we have the 2010 ADA, AA, the amended American Disabilities Act. And most people aren't aware. So basically,
most attorneys aren't aware.
They are not.
And I talked to them about that, and we can't handle this in the court right now. But you're supposed to handle this in the court right now. This is exactly where you're supposed to be. Handle this. You're violating due process. You're violating ADA right there every day.
Civil rights.
The minute that court opens up till it closes Monday through Friday, every person that walks in that door has their ADA violated, whether or not they're disabled. I'm telling you, this is the absolute truth. Big issue. If we can knock the ADA out, we've won everything.
You're absolutely right. But it goes a step further. Every other state, every other of these 50 some odd states, is grievance procedure. If you are disabled, if you want to make accommodations, denied. New York's grievance procedure is non-existent. It's file an appeal. Why do you need a judicial appeal for an administrative ADA request? I need a note taker. No, you can't have one. You're not disabled.
You need way more than a note taker.
Okay. So, but the problem we have, in essence, to expose this, and I appreciate you inviting me on the show, thank you, is the issue we have is family court is private. They would not let my aide, who was carrying my papers to go in the courtroom, they would not let my driver accompany me into the courtroom. They sent it out.
When you say they, though, who exactly
the family court.
Who's that's just a box.
The family court, right.
Who would not, who's
the judge. Disability discriminating Judge Shower.
The Judge Shower.
Right. But my ex.
Dishonorable Judge Shower.
But my ex-wife, who had her army of attorneys, had 3 note takers in because they knew that the transcripts are so poor.
So the judge allowed it for her.
The judge allowed it for her. And this is what's amazing. So they said, for you as your accommodation, order transcripts. In my transcripts of over 28 court proceedings, there's over 1,800 inaudible words. So how do you understand the meaning of what is said or ordered if it's inaudible?
Very wrong.
And here's where New York State has a real problem, because since 2015, Governor Cuomo ordered this court system. This court system can produce a transcript same day. They don't want to use it because they don't want to accommodate you. They want you to violate. They want you to go to court for not following or not remembering. How do you remember when you don't get reasonable accommodations? How can you get reasonable accommodations if they don't think you're disabled? How can you appeal if the people you're disabled to saying you prove disability? Under 2010 law, proving disability is minimal. They have 8,000 pages of certified records. They have letters from surgeons. They have 3 different implants. Traumatic brain injury is listed as a disability in the 2010 amended ADA. And they said, no, you're not disabled. So she didn't have to accommodate you. So disability discriminating Shower did nothing wrong. Now we're trying to go to the Court of Appeals.
And now you have right here, July 9, 2018, United States Southern District of New York. This is your new one, right?
This is my amended federal complaint, right? Amended federal complaint. And basically we had to sue in January of 2018 in order to get Office of Court Administration to order Judge Shower to issue a final order, which she did in the middle of June. We had to get the court itself to order it because the appellate division wouldn't take an interim appeal because under Article 6 or 8, you have no right to interim appeal under these articles. Right. And so you get caught in this vicious cycle. Under ADA,
it's intentional.
Under ADA, you always have right to appeal. No, you don't. Article 6 or 8. And the judge, of course, wouldn't recuse herself over the years, and was going through a divorce
well,
herself.
She might recuse herself now because there she is. Am I doing that right? There she is right there, folks. There she is. Well, I really appreciate having you on.
Sure.
Appreciate having Elizabeth on.
Thanks for having us.
We're going to show a solution right now with Don Rufty and the executive order that we need you guys to all sign, please. The executive order to jail the judges, which is under Section 18242. And then we're going to show you a wonderful event that's happening September 8th to 12th for the children at Washington, D.C., and the Ed panel will be speaking before Congress. So here we go.
Hello. The proposed executive order mentions several items in the law, which I'm going to go over at this time. U.S. Code Title 18, Section 242 is mentioned because it forms the basis for incarceration for the crooked judges or any other government official who violates anybody's rights at any time. These are addendums or exhibits that accompany the proposed executive order. Exhibit A, U.S. Code Title 18, Section 242, Deprivation of Rights under Color of Law. Section 242 of Title 18 makes it a crime for a person acting color of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. For the purpose of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting color of law within the meaning of this statute include police officers, prison guards, and other law enforcement officials, as well as judges, care providers in public health facilities, and others who are acting as public officials. It is not necessary that the crime be motivated by animus toward the race, color, religion, sex, handicap, familial status, or national origin of the victim. The offense is punishable by a range of imprisonment up to a life term, or the death penalty, depending upon the circumstances of the crime and the resulting injury, if any. That's U.S. Code Title 18, Section 242. Pretty clear. Exhibit B, the Federal Rules of Criminal Procedure. Rule 3, the complaint. The complaint is a written statement of the essential facts constituting the offense charged. Except as provided in Rule 4.1, it must be made under oath before a magistrate judge, or if none is reasonably available, before a state or local judicial officer. Rule 4, arrest warrant or summons on a complaint. A, issuance. If the complaint or one or more affidavits filed with the complaint establish probable cause to believe that an offense has been committed and that the defendant committed it, the judge must issue an arrest warrant to an officer authorized to execute it. At the request of an attorney for the government, the judge must issue a summons instead of a warrant to a person authorized to serve it. A judge may issue more than one warrant or summons on the same complaint. If a defendant fails to appear in response to a summons, a judge may, upon request of an attorney for the government, must issue a warrant. That's Rules 3 and 4 of the Federal Rules of Criminal Procedure. The Supremacy Clause is also mentioned. That's Exhibit C. The Supremacy Clause of the United States Constitution, Article 6, Clause 2, establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land. It provides that state courts are bound by the supreme law in case of conflict between federal and state law. The federal law must be applied. Even state constitutions are subordinate to federal law. In essence, it is a conflict of laws. A rule specifying that certain national acts take priority over any state acts that conflict with national law. In this respect, the Supremacy Clause follows the lead of Article 8, the Articles of Confederation, which provided that every state shall abide by the determination of the United States in Congress assembled on all questions which by this confederation are submitted to them. Constitutional provision announcing the supremacy of federal law, the Supremacy Clause assumes the underlying priority of federal authority, at least when that authority is expressed in the Constitution itself. No matter what the federal government or the states might wish to do, they have to stay within the boundaries of the Constitution. This makes the Supremacy Clause the cornerstone of the whole American political structure. This is the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding.
No, not much to do, so.
Thanks for doing this.
You're so welcome.
My pleasure. You know, I will call you.
The other one you wanted to do, my advocate, my ADA advocate, Donna Trump, she's a
People are
professor
writing.
at Mercy.
People are writing. Arrest them right now.
Arrest who, us?
The judge.
Oh.
So where's
Okay.
put them on Facebook?
On Facebook, it's live right now. YouTube is live right now, and like he's a broadcaster, so he has an multimedia broadcasting, and it goes out on 18 other broadcasts, and I don't even know how they are.
So
I just